Good afternoon. Got a lot of people joining us. We're going to give this just a minute, give everyone a chance to drop in on the call. Looks like we've got a few more people jumping in. All right. I'm going to go ahead and get started. Good afternoon. I want to welcome you on behalf of the Arkansas Small Business and Technology Development Center, as well as our partner SBDC offices in Texas, Mississippi, Oklahoma, and Alabama. Thank you for joining us today for Intellectual Property Basics with the United States Patent and Trademark Office. I'm Meredith Thomas, and I'm a communications specialist with the Arkansas Small Business and Technology Development Center, and I'll be your webinar today. Today, we are pleased to have the Texas Regional United States Patent and Trademark Office with us for an engaging session on intellectual property and the importance of IP protection for your business. We're joined today by patent examiners Kathleen Fisk and Bert Phillips, Christina Calloway, an attorney for trademarks, customer outreach, and supervisory patent examiner Peter Choi. Before we get started, I want to cover a few housekeeping items. You will receive a copy of today's presentation slides, as well as a link to a recording of the webinar. So if you missed something and you need to go back and listen, that will be available to you. Your cameras and mics will be turned off during the webinar, but if you have questions, please put them in the Q&A box located at the bottom of your screen, and we will address those as many as we can at the end of the presentation. So without further ado, let's dive into our session. Kathleen, I'll hand it over to you to kick things off.
All right, thank you. Let me go ahead and share my screen real quick. Make sure you guys can see that. All right, and thank you, Meredith, so much for that wonderful introduction. I wanted to give our team a chance to introduce ourselves a little bit more, just to give you a little bit more background of who we are with the Texas Regional Office and the USPTO. So I am Kathleen Fisk. I am a patent examiner for the U.S. Patent and Trademark Office. I specifically examine exercise devices. So we're all separated into specific technology areas, and I'm currently on a temporary career development position with the Texas Regional Office, helping them out with their outreach, which includes educational opportunities like this to just spread awareness of intellectual property to small businesses and entrepreneurs. And with that, I am going to pass it over to Bert Phillips, and he can introduce himself real quick.
Hello, as Kat said, my name's Bert Phillips. I'm also on the same career temporary assignment that Kat's on. I'm a primary patent examiner with the Patent Office. I examine patent applications in the database and file management areas. Been with the office since 2007, and so I look forward to doing this presentation to y'all. And so I'll pass it on to Christina.
Thank you, Bert. My name is Christina Calloway. I'm an attorney advisor in our Trademarks Customer Outreach Office. We're the office that is responsible for providing trademark-specific programming and presentations to entrepreneurs like yourself around the country. I have been with the agency for about 8 years, and I was a former trademark examining attorney, the attorneys that actually review those trademark applications when they come into the USPTO. Thank you, and I'll hand it over to Peter.
Hey, good afternoon, everybody. My name is Peter Choi. I've been with the agency since 2004, so this is my 20th year. The first 8 years, I was a patent examiner in an area called business methods, and the last 12, I've been a supervisor in that same area. And I also work out of the Texas office, where in addition to supporting and managing examiners, I support the outreach activities like the ones that we're doing today.
All right, so with that, we will jump right into our presentation, and we are going to be covering intellectual property basics today, as well as some USPTO resources that are available to you all. So starting with the background of intellectual property, the first rights for intellectual property are actually found in the U.S. Constitution. So in Article 1, Section 8, Clause 8, we look at the language there to promote the progress of science and useful arts, by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So this one really focuses more on the copyrights and patents aspects. Trademarks come in a little bit later, but it just goes to show that even our founding fathers were considering intellectual property rights as something very important to US citizens. And so they even put it into our Constitution to make sure that we have those rights secured for us. A quick overview of the USPTO for our last fiscal year, which would have been fiscal year 2023. We are quite a large government agency. We have almost 13,500 employees total. Of that total, we have around 8,500 patent examiners, getting up to closer to the 750 trademark examining attorneys, 225 administrative patent judges. So those are going to be our patent trial and appeal board judges, and then 28 administrative trademark judges. So the trademark trial and appeal board judges. Our patents department in fiscal year 2023 saw over 650,000 applications. That does not necessarily mean that they reviewed 650,000 applications, because we're on a continuing basis receiving those applications and reviewing them as they come in. But we did issue 346,000 patents last fiscal year, which is a pretty good number when you look at the totals. For trademarks, we do see a higher volume of trademark applications. So we had 737,000 trademark applications with 414,000 registrations go through last year. The image at the bottom of the screen, that is our headquarters. Our headquarters is located in Alexandria, Virginia. It's a beautiful campus if you ever have a chance to stop by there. I mean, the Madison building is really nice, and our grounds are very beautiful to just walk around. And it's a great area in Alexandria if you ever have a chance to visit. In total, right now, the U.S. Patent and Trademark Office has 5 regional offices or regional outreach offices. So with our headquarters in the Eastern region, we have the East Coast Regional Office or the Eastern Regional Office. We also have the West Coast, which would be Silicon Valley or our Silicon Valley location. Rocky Mountain, which is located in Denver, and our Midwest region, which is located in Detroit. And then there's us down south in the Texas Regional Office. However, we do have a 6th office opening up in fiscal year 2025. That will be headquartered in Atlanta, Georgia. That will become our Southeastern Regional Office. So keep an eye out. We cover these different regions for outreach and education purposes. I do want to make a quick note, however, that does not limit who you will be working with at the USPTO. So just because you're located in Texas, if you file a trademark application or a patent application with us, your actual examiner could be anywhere across the United States. We have examiners in all 50 United States, Alaska, Puerto Rico, we're everywhere. So your examiner might be in a different time zone from you. The regional offices are here for more of the education and outreach, and to be a closer access point if you do need assistance from the office. Like I said, the Texas Regional Office, we are located in Dallas, Texas. We are covering 8 of the southernmost states. Our office is located right by the Reunion Tower. We do not have the Reunion Tower as part of our office. That's that ball that's at top that looks like it's sitting on top of our office building. That's actually the hotel behind us, but it is a beautiful structure. We're located in the Federal Annex or the Federal Terminal Annex building. We are open from 9 to 5 Monday through Friday. If you do have questions, you are more than welcome to reach out to us. We have people on site that can help you out. Within our office, we have patent examiners, we have PTAB judges, and then we have our management and staff as well. We do have a public search facility that is available for use downstairs. We actually cover the 1st and the 5th floors of this building. So on our 1st floor location, we do have public search facilities with computer access. You can access the different USPTO resources. We have informational and educational flyers there to help you out with any of your questions. And then if we are available, we are also more than happy to come down and help you out with specific questions. We also have PTAB hearing rooms. So those will be for our patent trial and appeal board hearings. The judges use those, the public uses those. If they have a hearing, you're more than welcome to come in. We have examiner interview rooms where you can meet with your examiner if they are located at if they are located in the Dallas region. And then we also have public meeting space that we do allow other agencies and other groups to come in and use from time to time. And we'll use that space as well for educational and training events. And with that, I am going to pass it over to Bert to start our discussion on the types of intellectual property.
Okay, thanks, Kat. Appreciate that. So, yeah, thank you. So intellectual property is a lot like regular property, right? It's just kind of intangible. So you have your regular property like cars, houses, and you have intellectual property. They're similar in that you can buy and sell regular property like you can a car or a house. You can rent a house or a car in the same way, similar, not quite a perfect analogy, but it's you can also license software. So that means it's a type of renting, software to other people. So that is kind of when we talk about intellectual property, it is a type of property. So and that's important when we discuss things like patents, copyrights, trademarks, and trade secrets. Okay, we can go to the next slide, please. Okay, so now here we go. So this is a kind of an intro to all the 4 buckets of IPs that we're going to talk about a little later on. This just kind of gives you a broad overview of different types of intellectual property that can be found in just one product, like a cell phone. Again, we're going to go over these in more detail later, but you've got design patents on the home button, the way the phone is shaped, the way it's curved, You got copyrights on the instruction manual, the code that goes into the operating system and the apps for the phone. The ringtone is a copyright, right? Trade secrets, we'll get into that later, but we don't know because you have to keep it. One of the elements of trade secrets is to keep it a secret. So we'll get into that later. Trademarks, Samsung made, Galaxy Note, those things identify the source of the goods, where it's from. Christina will talk about that a little bit later. And then of course patents, all the functional aspects of the phone, the camera that takes the picture, the battery, screen, etc. That even the software, the data processing methods of the software can be patentable. And of course the structure, like the circuits, can also be patented. So that's a kind of a broad overview of all the IP in a mobile phone. Okay, next slide, please. All right, now let's talk about US patents. Okay, go on to the next slide. And so when we talk about patents, most people kind of have a general idea of what it is, but and it's obviously it's a type of intellectual property that covers inventions, right? But what a patent document actually does, or what a patent actually does, is give you the right to exclude others from making, using, selling, or offering for sale your invention. It's a subtle difference, but it actually doesn't give you the right to or make or use the invention yourself. It gives you the right to exclude others. Now, that's a subtle difference, but it is a difference. It doesn't mean you can't practice your own invention, but it's just the technical reason that the technical definition of a patent is the right to exclude others, meaning you get a monopoly for a limited time, right? You get a monopoly for a limited time. Anybody that wants to use your invention or import it, sell it, etc., has to come to you for a license. Now, what happens is you have to, in order to get that limited monopoly or that monopoly for a limited time, you have to provide disclosure to the public so that someone can make and use the invention by reading the disclosure, right? Now, patents also are territorial in that they only cover the United States. If you want to get a patent in another country, you have to go to their particular patent office to get those rights. Also, under the patent statutes, we only protect certain categories of invention, and so those are listed there on the last bullet point: process, machine, manufacture, composition, matter, or improvement of those. Most patents, as you'll see, are improvements of those things, right? So again, those are the 4 statutory categories of invention. If they're not in those statutory categories, then you can't get a patent on them. Okay, next slide, please. All right, types of patents. Okay, let's go to the first one. Utility is what we talked about. What you usually is what if you're talking to somebody, you know, a layman or whatever, that's what you usually think of when you talk about patents. People say patents in a normal conversation, you're usually talking about a utility patent, right? These are what I just mentioned before. One of those 4 statutory categories of invention. You know, if you think like a light bulb, things like that. This is a patent that Abraham Lincoln had of a vessel. So that's what people say utility patent, or when people say patent, they're talking about a utility patent. And for utility patents, you have once you get the patent granted, you have 20 years from the date of filing of your first non-provisional patent application, just meaning the filing date, 20 years from the filing date. So that's how long the term lasts for your patent. After that, it's turned over to the public for the public to use. Again, it covers those 4 statutory categories of invention. Okay, next slide, please. There's another type of patent that's a design patent that covers kind of, generally speaking, the non-functional aspects of an article. It protects the way an article looks. So this is a root beer bottle. You know, the curves of the bottle, the lip up there, the kind of the lines in there. Can we annotate? Should I try to annotate? Should I dare do this? So things like this, like the non-function kind of the way the design of the bottle is, right? These lines, right? Anyway, so that's what a design patent it covers kind of the non-functional the aspects of the item of the article. Okay, let's go to the next slide. Oh, I knew that was going to happen. Okay, how do we go ahead? How do we get rid of that? Sorry, I'll erase it. Let's see. We'll just do this. There we go. I got it. All right. So plant patent, plant patent. This is a specific type of patent that is just for plants, and it protects asexually reproduced distinct and new plant varieties. It also has a 20-year term. Now, I looked up. I'm not a botanist, but I looked up. I looked it up, and asexual reproduction is just cutting, layering, division, budding, and grafting. If you're a gardener, you might know what those are. But that's how you have to reproduce the flower or reproduce the plant in order for you to get coverage on it. You can't, for example, get one on a tuber propagated or a root vegetable, right? So that's just the rules. And again, this is very. I think that we might have 2 or 3 art units in the whole United States Patent Office that do these. So they're relatively rare, but just know that is another form of IP protection that's specific to plants. Okay, next slide. Okay. Now, here's how this is kind of a broad overview of how you get a patent, and this is kind of assuming, well, it's any of the patents, but we'll just go with the utility patent for right now. So you have an idea, you have this. What you can do is file a provisional application, which is obviously you see that's optional there. And what that does is it's a placeholder that retains your filing date and you have that for a year to get a non-provisional application. Provisional application is not examined by people like me or Kat. We don't look at the provisional applications except in limited circumstances. So the provisional application is kind of an informal application. It can be any kind of disclosure you want, but it does have to have it for you to get the filing date. You do have to have enough in there to what we say enable the non-provisional, but it's kind of beyond the scope of this presentation. But all I'm trying to say is that the provisional application can be pretty much anything. It could be a research paper. It could be drawings, you know, hand drawings. It could be there's no regulations or rules provided by the Patent Office that for provisional applications. But the non-provisional application again, you have a year to file your non-provisional to get the filing date for the provisional. Non-provisional application is what I look at, Kat and I and the others at the patent office look at to examine it for all the statutory requirements for a patent when you do the search and everything. And once it gets past us, then we will what we call allow it or issue the patent. So again, the provisional is just an optional step that kind of preserves your filing date, and it gives you time or gives you a year to kind of work on the non-provisional application. Okay, next slide, please. Okay. These are just fun things we like to do. Sometimes talking about patents can be a little bit dry. So let's go to the next slide and we'll see what we got here. So I'll just wait for a few seconds and let you guys read that. TV control, adjust the volume from your sofa, variable length, less expensive, functions efficiently. Okay, next slide. And it's a stick that goes to, it's kind of funny. Anyways, different one you probably thought it was, but that's back in 1976. That was registered. You can look that up. I imagine it's expired by now, but anyway, that's a kind of a funny invention that somebody filed for and got granted. Okay, next slide. Okay, this is fresh air breathing device. So you're in your house and the smoke fills the room. For whatever reason, you can't get out of the room. You're coughing. So you have this tube that you can breathe fresh air. Now, how are we going to get the air from the tube? Okay, next slide, please. Well, you stick it in the toilet. Apparently, this works. And so this was done in a movie, a TV show too. They should explain that in a TV show. So anyway, that's kind of interesting invention there. Okay, next slide. A pet gadget with the umbrella and a leash. Protect your pet from weather and serves as a leash. Pretty self-explanatory. No surprise here. Next slide. There we go. It's an umbrella attached to a leash. Kind of a neat idea. 2005. I think you probably can. This might be available for sale still. I'm not sure, but I think at one point this was on Amazon. I'm not 100% sure, but maybe you can look it up. But anyway, so that's pretty interesting. All right, so we went over some. Okay, now we're going to talk about trademarks, and I'm going to pass it on to Christina.
Thank you. All right, let's get into trademarks. So let's kind of connect it to what Bert just told us about patents. So you have your patent, your invention, and you may want to call it something, or you may have you may want to call a product something, or you have a business and you have a name for that business, and that would be a trademark. It's a word, phrase. It could be a symbol, design elements, combinations of words, letters, numbers that identify or distinguish the source of your goods or services from those of another party. So trademark is in reference to products or good, and service mark is in reference to services. So you may hear the words trademark or service mark, but we use the word trademark interchangeably for both goods and or services. Next slide, please. So these are some examples of trademarks. It is said that in a day, a public consumer is going to see about 10,000 different trademarks in connection with products and or services. So like we said, the trademark can be any combination of words, terms, phrases, numbers, combination thereof, design elements, color. So like here we have Starbucks, Nike, Target. These are registered trademarks. They came in for the standard form of those particular marks, but we don't normally see them in the marketplace in this particular manner, right? For Starbucks, we see that green and white two-tailed mermaid. For Nike, you may see that black Nike swoosh. And for Target, you're going to see that red and white bullseye. So you see how trademarks can be any combination of design elements, different font stylizations, combinations of words, phrases, etc. So anything that could possibly be used as a trademark could possibly be eligible for registration, as we're showing with these different types of marks. Next slide, please. So here we have some non-traditional marks, colors. So like I said, trademarks can be anything that you are using to identify or distinguish your goods from those goods and services from those of another party. So a color can be distinctive enough to and used in a manner that it could identify the source of those goods and services. So here you see the Tiffany Robin's Egg Blue on the outside packaging. If someone were to hand you that particular box, you'd probably get really excited because you know there might be some nice jewelry goods inside of the box, right? So that color is distinctive enough to indicate the source of that particular good or product, right? Tiffany's. You see the brown of UPS, that brown outside of the truck or on those uniforms specify delivery services for UPS, as well as with John Deere. If you've seen those products, those lawnmower products, those types of riding lawnmower products, they are usually in the color of green and yellow. So that indicates the source of those particular goods, that John Deere company. Next slide, please. Some other non-traditional marks are scent marks. Play-Doh is one that most people have heard of or know about, in that those clay molding compounds have a distinctive smell or scent. So even as an adult, you probably remember the smell, or if you have little ones around that are playing with Play-Doh, you probably remember that distinctive smell of Play-Doh, and that is a registered trademark for those particular goods, as well as the liquid power Groovy Grape. This is a type of good for your vehicle, for your automobile, so that when the exhaust comes out, it has a particular scent or smell that indicates the source of these particular goods in connection with that particular scent. Next slide, please. And then other non-traditional marks such as sound. So we have the Pillsbury Doughboy, those NBC chimes that you may hear at the beginning of a TV show, or when you're turning on NBC, hear those 3 chimes in connection with those television broadcasting services, or this coin ching sound that can be in a reference to games or software, computer software games. So you see that whatever you might be using that is distinctive to identify the source of goods and services could possibly be eligible for registration. Now, we normally see what you would call, we don't necessarily say trademark, right? You probably say, I have a logo, I have a brand name, I have a slogan that I'm using in connection with my business, with my products, or with my services. And those are more common types, but we're just showing here some non-traditional types of marks as well. Next slide, please. Going forward, I think it went backward. Thank you. Thank you. And we have trade dress. So this is different types of distinctive elements of the design that could also be a trademark. So here we have that Doc Martin boot that has that yellow stitching around the bottom of the boot, above the sole of the boot. You have the shape or the style of an Apple store. The way that it's laid out and planned as trade dress could be a trademark. Those Hershey kisses, or the shape of, and one of the most popular that people know, are the shape of that Coca-Cola bottle. Your trademark has to be identifying the source of goods and or services. So when you're thinking about these types of marks, even the non-traditional ones, think about the types of services or goods that are connected with those marks. So even with that Coca-Cola bottle, if you were to see that bottle, even without the labeling, you probably know distinctively that it is for that Coca-Cola product, that carbonated soft drink product. Next slide, please. And we'll just quickly go over some copyrights. The copyright portion, and Kathleen will talk about this, about the resources, is not, you wouldn't come to the USPTO to get registration. That would be at the Copyright Office at the Library of Congress. We will just briefly go over what copyrights are in the context of intellectual property. Next slide, please. So a copyright is a legal protection of an original work of authorship, literary, dramatic, musical, artistic, or certain other intellectual property works. A copyright has to be in a fixed, tangible form. So think about if you're writing a song and you're writing that song and the words of that song on a piece of paper. As soon as you write that song down on that piece of paper in that fixed, tangible medium, then you have a copyright. You just don't have a federal registration of that copyright until you go to the U.S. Copyright Office, but you have a copyright as soon as you're putting that original work in a fixed, tangible medium form. Next slide, please. So what is protected by a copyright? So Bert talked about what's protected by a patent. Trademark registration is protects your logos, your brand names, your slogans, and a copyright is going to protect literary works or original works of authorship. So think about songs, books, sculptures, movies. It could be choreographic works. It could also be computer software. So those which are more non-common that we're thinking about when we're protecting by copyrights, but usually we're thinking about more original works of authorship like the ones that are shown on this particular screen. Next slide, please. Other works protected by copyrights are logos. It could be product design and packaging, advertising and promotional materials, instruction manuals, education materials, software source code, and website content. Remember, it is anything that is an original work of authorship that is in a fixed, tangible medium. Next slide, please. And I'll throw it back to Kathleen to discuss trade secrets. Or Jacob, Peter, I'm sorry.
We're actually going to pass this back over to Bert. He's going to cover the trade secrets.
All right. Sorry, no problem. All right, we can get on to the next slide, Kat. So trade secrets, like Christina said, with respect to copyrights, there is no, you wouldn't go to the patent office to get a trade secret, right? There is no, actually, there is no federal agency that kind of issues or grants trade secrets, right? There are federal statutes that covers trade secrets, and their common law, state laws, that pertain to trade secrets, but there is no agency that issues trade secrets. And once we kind of explain what it is, it makes sense, right? So this is just secret information that gives you a competitive advantage in a business. It's kind of a broad definition. Includes formulas, patterns, compilations, programs, device, method, technique, or process. Like, what in the world? What in the world is that? So I like to. This is one of these examples of intellectual property where it's easier to tell you based on the examples. So, Kat, can go to the next slide. So for example, the recipe for fried chicken at KFC, it's secret herbs and spices. Those are trade secrets. Nobody really knows what those are. Coca-Cola, formula for Coke. How they make the Krispy Kreme donuts. Another big one that you guys in business, about this one probably if you have any type of business online or have any online presence, which is everybody, search engine optimization. How do you get to the top of Google page rank? How do you get to top of Google search engine when you type in a name, right? Nobody really knows how that happens. You can kind of guess, but they change it. It changes a lot. That is definitely a very powerful and very lucrative, very one of the best things that Google has as a trade secret, right? So those are all four kind of really good examples of what we'll call trade secrets. Okay, let's go to the next slide, please. So patents and trade secrets. This is kind of a trade-off. Like if you're trying to think, should I get a patent on this particular invention or idea or process, or should I maintain it as a trade secret? This is kind of a slide that shows you the differences and the similarities, or I guess you say differences of them, right? So for patents that are limited time, right, you have to disclose the invention so that one skilled in the art can make and use it. That just means a person can make and use the invention by reading the specification, right? You can't hide the ball, as we like to say. You have to provide enough disclosure to actually make and use the invention. And in exchange for that, fancy word, quid pro quo, right? You get an exclusive monopoly, or you get a monopoly for a limited time to exclude others from practicing that invention or importing or selling, etc., right? So, if someone wants to use that, or someone wants to practice your invention or use your invention, they have to come to you to get a license. If they don't, you have remedies such as, you can sue in district court, among other things. Now, a trade secret does not have a length of time associated with it. As long as it remains secret, you have protection, right? So what happens is you have protection until the trade secret is no longer secret. You have to take reasonable steps to keep the trade secret. What does it mean to keep it secret? It means that, you have to take reasonable steps. You have to have only certain people can have access to the secret, right? If you publish this trade secret on your website, that's not a secret. Now, another big difference is, for example, trade secrets can be reverse engineered, right? Because you don't know how to kind of make the Coke formula, for example, right? But if you can buy a Coke off the shelf and reverse engineer it and make your own soda that tastes kind of like Coke based on you reverse engineering the Coca-Cola, for example, then that's okay. That's reverse engineering is okay. On the other hand, if you think about patents, reverse engineering doesn't really make sense, right? You have the secret sauce in front of you. You've got the disclosure in front of you. So there is no reverse engineering. If you want to make and use this invention, you have to take a license from the patent owner as long as the patent's still, valid and in force. So those are kind of differences between a trade secret and a patent. Okay, Captain, go to the next slide, please. All right, this is just kind of all what we've all gone over, all the different types of intellectual property. Kind of gives you, I won't read the slide, but we're just kind of goes over what's protected, kind of the statutory requirements, the common law requirements, what it protects against, and how long it lasts, right? So you've got things like trademarks and trade secrets that are pretty much last into perpetuity unless a particular thing happens. Like if you abandon a trademark or you publicly disclose your trade secret, then you're done. The other ones, utility patents, design patents, copyrights, have a limited scope, right? Life of the offer plus 70 years, 15 years from grant for the design, and 20 years from the filing date of your first provisional for the utility patents. So again, this is just a good slide to kind of give you kind of an overview of all the different types of intellectual property we discussed. Okay, next slide. I think that's it. Yep. Okay, pass it back to Kat for the resources.
All right, thank you, Bert and Christina, for going over our 4 types of IP. I did want to address one question that we've gotten in the chat. Most of these questions we will address at the end. However, since we just finished these 4 buckets of IP, I feel like this is a good spot to put it in. We have one question in the chat that says there seems to be an overlap between trademarks and copyrights for things like logos. Do you need to have both for things like a logo? This is a great question. So a lot of intellectual property rights do overlap with each other. They're different types of protection. So I'm going to go back to that chart real quick. There are different types of protection, so you want to make sure you are protecting it in the way that you want to, but you do not necessarily need to have a registered copyright and a registered trademark at the same time. That is a personal decision that you'll make. That's a legal decision that you'll make. We can't give you advice on which way to go. But just for other examples real quick, I know we had mentioned different software source code for a copyright. So the written material of the source code or the written material of that actual coded language can be copyrighted. However, you can also receive or potentially receive a utility patent for the actual functionality of that source code. Again, there's different requirements for each of these types of intellectual property. So you want to make sure you're protecting the correct thing when you're looking at it. But we do see a lot of that overlap. Logo is a great example. You can have that copyright and the trademark. Designs, we had both a design patent and trade dress. So there's different ways that you can protect your invention or your creation. And you just want to make sure that you're looking at what is being protected by that right and how you want to use that within your business. All right, so with that, I'm going to jump into some USPTO resources that are available to you all. These are all free resources that are available to you. Just heads up, not putting any advertising in here. So just again, we're the Texas Regional Office. For any of our southern states, we are going to be your point of contact for questioning if you have specific questions that are not directed to one of your examiners. So if you just have general questions about a process for an application or something on our website, something like that, or a training, you're more than welcome to reach out to us. We do have our own webpage that you can find and link to that has our contact information on it. We also have the Texas Regional Office alerts, the USPTO alerts, that will give you email updates about different trainings that are coming up or different activities that we'll be partaking in so that you can join and potentially expand your intellectual property knowledge, or again, ask questions if you have specific questions. The USPTO Inventor newsletter, this is another one that you can sign up for through the Inventor website. It provides information to inventors and entrepreneurs about the latest updates within the USPTO. So things like our director memos that come out, or new information on resources or new educational materials will come through that Inventor newsletter. So just another easy way for you to get email updates about what's going on at the USPTO and potential information that could help you out on your journey. Startup resources. So we are not a funding agency. The USPTO does not offer funding for inventions or creations, anything like that. But we do have our government agency partners that do have funding available. So on our startup resources webpage, you can find links for different areas of potential funding opportunities that you can look into. There's links for different advice for how to start your business, things like that. But just wanted to make sure that you all are aware of this. This is a great one-stop shop to kind of link to those other agencies or other groups that can help you out with the actual development of your business, the funding for it, and the expansion of your business as well. We offer a couple of different educational classes at the USPTO to help you out with your intellectual property journey. The Path to a Patent is a training series that covers everything from similar to this class that goes over the 4 different types of intellectual property to the actual patent application process, and then what will be done with your application at the office. So that includes patent searching, things like that, and it'll help you with getting to the point of actually submitting your application. So we offer these throughout the year, and I think we offer one class each quarter, and it is a series of classes. You do not have to take all of the series. You can sign up for specific ones if you'd like that you're interested in, and so you can find all of those on our event web pages. They are all offered virtually. Our Inventors Assistance Center, this you can kind of think of as a hotline for help at the USPTO for patents. If you have a question on how to submit your application or what you need to do for your application once you have submitted it, you can contact the Inventors Assistance Center, and we have people that are there to support you with that journey and to kind of help guide you to the different steps that you may need to take. They can connect you with different resources. However, this is not a conversation about your actual patent application being granted. That would be a conversation you would have with your examiner. So this is mainly support for the background and the technical aspects of your patent application. Patent Public Search is our online search tool that you are more than welcome to take a look at. It is the same platform that patent examiners use internally. However, it only allows you to search United States patents that have been published and United States patent publications. So it has both granted and currently pending or abandoned applications on there that you can look through as prior art. I will say it is a little tricky to get used to. It is a different language of searching. The way that you work or the way that you type your search query into it, it's not just like a natural language Google search, but there are training materials on the website. When you go to the main page for the Patent Public Search, you can find training videos, different quick guides that can help you out and help you through working through a search if you're trying to see if there is prior art or a past invention that would not allow your invention to be granted a patent. Trademark Basics Bootcamp, this is similar to that Path to a Patent. So it's another free training series that provides that overview of a trademark registration application and maintaining a federal trademark. So again, it's all online. You can look up the classes and sign up for the ones that interest you. And you can kind of get more information on that trademark application process and see if there are specific things that you need to do to work up to that step. We also have the Trademark Assistance Center, just like the Inventors Assistance Center. This is going to be your go-to hotline for questions on trademark applications. So the background of your trademark application or the actual technicalities of it. Again, this is not a conversation about the actual granting of a registration of your trademark. This is talking about the background support for the technical aspects or the formalities of your application. So they have a phone number and an email address, just like the Inventors Assistance Center, and they are available to support you through the actual application process. So in terms of patent fees, we get questions a lot about the patent fees. We have the opportunity to qualify as a micro entity status for our patent fees to receive up to an 80% reduction on the majority of the fees that you would potentially encounter during your application process. So you do have to qualify for these. There are specific requirements that you can search for through our website. If you just search USPTO micro entity status, that will give you the guidelines on how you can qualify for this type of reduction in pricing. We do always recommend filing electronically. That is our preferred system for filing patent applications and trademark applications. We do still have people that mail in applications. It's completely up to you if you want to mail in a paper version. But if you go through our EFS web, which is our online portal for patent applications, you would avoid that surcharge for it with that micro entity status. So just a way to kind of reduce those fees. We understand that patent applications can get costly. And so for smaller inventors or smaller businesses and just entrepreneurs starting out that want to look into those, into getting a patent for their invention, we do want to make it more accessible. The Patent Pro Bono program is a free legal assistance program across the United States for filing a patent application for inventors and businesses, so for independent inventors and small businesses. These are attorneys, they're registered attorneys who offer their time and they volunteer their time to help out some of those smaller businesses, independent entrepreneurs, independent inventors, work through the patent application process. So this is another great resource to kind of save some of those costs that's available to you. Again, we know it can get costly, especially on the external side with attorney's fees. We're not involved in the attorney's fees. Those are all on an individual basis of the attorney, but this is just another way to help you out and kind of avoid some of those more costly aspects of a patent application. We also have law school clinics across the United States. So law school clinics are certified through the USPTO to assist you with filing a patent or trademark application. Each law school clinic may focus on one or the other or both. So you can have a law school clinic that only focuses on patent applications, and then you can have another one close by that only focuses on trademark applications. So if you're looking to go through one of the law school clinic programs, just make sure that they cover the type of intellectual property that you're looking for. They will function in the same way or similar way to the Patent Pro Bono program. It's free legal assistance to help you with the application process, but you do have to request to get their services. So you have to go through whatever their request process is, and they will approve or deny depending on their availability and their ability to help you out. So just another option for you to look into as a good resource to save some of those costs on attorney's fees. The PTAB Pro Bono program would come in handy during your patent prosecution. So this is something that would come after your application is filed, after it's been examined. If you are looking to prepare something to present in front of the Patent Trial and Appeal Board, this is a way that you can, again, get some of that free legal assistance to help you out if you're one of those small inventors or small businesses. I'd suggest going to their website to, again, look at some of the requirements for it. They're just like the Patent Pro Bono program. There are certain requirements to get into it. We're not going to offer this to a really large company because they have the resources to get that legal assistance. So just make sure that you look at the qualifications and look at what they need as their requirements before reaching out to them. Patent and Trademark Resource Centers, or PTRCs, are libraries that are located across the United States that offer more information about patents, trademarks, intellectual property, and then, of course, the application process through the USPTO. So they offer classes as well independently from the USPTO. So on their own, they will present to the public to give more of that information. They have experts on site that can help you out with navigating our website, navigating the patent public search tool, or just directing you to the correct resources that you need for your question. So we've got quite a few that are in the southern states, and then of course we've got many across the entire United States. So if you are looking for one, if you go to the website, you can check them out by state and see which one is closest to you to get some access to those resources. Another way that you can save on this would be saving on the actual examination time of your patent, which can help speed things up, is our expedited examination programs. So these programs are built for specific types of inventions, except for track 1. So I want to point out that the first one on this list, the prioritized examination program, or track 1, is available to any type of technology, but you pay for it. So it is an added fee, an added cost to your patent application. And then the other ones that are on here, we got Cancer Moonshot, the Climate Change Mitigation Pilot, First Time Filer has requirements to it, and then the Semiconductor Technology Act. Those ones all have certain requirements that you need to meet in order to be accepted into the expedited examination. Obviously, Cancer Moonshot, Climate Mitigation, and Semiconductor, very technology specific. So you want to look up what type of technology they're accepting into those programs before applying for it. The First Time Filer, if you have never filed a patent application before the USPTO, you can request to be enrolled in the First Time Filer expedited program. And the goal of these programs are to speed up the examination process. So our examination pendency right now for typical applications that come in not on an expedited program is closer to the 2-year mark or 2-year and 2 months mark. We're looking around that time frame. These programs can cut that examination time down to a year. That's the goal with these programs, is we want to get you in and out with your patent within a year. Obviously, there are caveats to that if there's issues in prosecution or things like that that could extend the timeline. But it's just another way to kind of help you out and speed up the process of getting your patent granted. We also have a tool online called the IP identifier. I want to give a warning with this. This is not legal advice. It is not telling you what type of intellectual property you should file for. It's just a resource for you to think about the potential intellectual property that you have for your business. So it'll ask you a series of questions. It'll ask you those series of questions, and then it will provide you with kind of an analysis of the potential types of intellectual property you have. Use that as a starting point to do some research and to check in to see what types of intellectual property you might want to file for, what trademarks you might have to register for, what copyrights you should register for. So use it as a jumping point to get started on your research and started on your intellectual property journey. But just know that it is not legal advice. We are not telling you what types of intellectual property you should be applying for. We are on social media. So if you follow the USPTO on social media, you can get more updates about director's memos that come out, new rules and guidelines, events that are happening all across the country. We have in-person events and virtual events, such as these educational series that you're more than welcome to sign up for. And then you can just see some of the highlights from the USPTO. We'll do inventor spotlights sometimes, and we'll do different series based on the holidays that are coming up, the celebrations for that month. So just a way to keep up to date with the USPTO. And with that, this is our contact information. If you guys have more questions specific to what you're working on, or your patent prosecution, or your patent application or trademark application questions, you're more than welcome to reach out to us so we can connect you with more resources. You can give us a call as well. We do have an office manager on site who kind of forwards those calls to us. We'll get us in touch with, they'll get you in touch with us, and then we can help you out with some more specific questions if you have those. But with that, I will take it off to the Q&A. Please, if you have any questions, just go ahead and write them in the Q&A, and we will address those, as many as we can, in the time that we have left. am going to go ahead and stop sharing my screen though. Make it a little easier. All right, so the first question that we had in the chat is, what is the process for ITAR objects and security classified material? I am going to hand this off to Peter. He will be able to answer this one much better than I will.
Sure. Thanks, Kat. So before I answer this question, I'm going to take it back to something that Bert said. So the US patent system is based on quid pro quo. So in exchange for you telling us what your invention is and how it works, if you're the first to file that invention, you will get the exclusive rights for the limited period of time, right? So it's a little bit different for certain technologies, right? So ITAR, which is, I think, governed by international traffic in arms, so essentially military-based applications, security classified material. So in the US, we actually have the Invention Secrecy Act. So with the way that works is that there's kind of two paths. So sometimes when you file your patent application, hey, this research that I have done is funded by, for example, the Department of Defense or with the military contractor or something. So you kind of already know it's subject to secrecy orders. There's a second path where applications are kind of reviewed or screened through a process to determine whether it should be classified under these secrecy orders. So if it is classified under these secrecy orders, what happens is that it's examined slightly differently. So if you remember what Kat said that we have examiners in all 50 states and Puerto Rico, and that's absolutely true. So it's not that, hey, I'm in Texas, my application is going to be routed to a Texas examiner, or I'm in Chicago, so my invention will be routed to an Illinois examiner. We don't do that. So everything's filed through headquarters, and then they will route it to a specific examiner that's best suited to examine the case. So again, Kat's here in Dallas, she does exercise devices, but her colleagues, they're scattered across the country. So it's kind of dispersed based on the expertise of the examiner rather than a regional assignment. With the security classified applications, those are all examined in a secure vault at headquarters, so a SCIF, right? So everyone that works on those has to have security clearance. There's no internet, there's no phones, no nothing. So essentially, it's kind of almost working backwards. Those are kind of examined almost by paper, because even though our networks and everything are secure, we're not taking any chances that something can be hacked or infiltrated. So anything that has a security clearance is going to be examined in person in that SCIF.
All right, thank you, Peter. Our next question, I will direct this one to Christina. So it is, I plan to set up an LLC with a website that has the same name. I did a trademark search for some of the company names I like, and I found some existing trademarks which are similar but not exact. In some cases, the name is similar, but the business is very different. Can you describe how to know when you are infringing a trademark and when a small online business should purchase a trademark with the domain name?
Yes, so without providing legal advice, when you file an application with the USPTO, that trademark application, or even prior to filing, like you conducted that search, which you can conduct online at uspto.gov, the examining attorney is going to be looking through an analysis of what we call likelihood of confusion. We'd be looking in our database to see if the application that is being applied for, if there is similar marks that are currently registered or have been filed prior to that application that have a confusingly similar mark for related goods and/or services. So if it's identical, yes, it's going to be a likelihood of confusion, but we don't just look at it being identical. We look at whether it's confusingly similar, along with whether the goods and/or services are related. So that's the same analysis that you can use prior to filing the application when you're conducting the search to say, okay, I did find some applications or some marks that are similar. Let's look at the goods and services to see if they are related, so that you can know whether or not your application is probably more likely to go through toward registration. So you would be using that likelihood of confusion analysis as well prior to applying, because once you apply and pay the fees, you don't get those fees refunded back when that application does not go through to registration. So you're conducting that search and using that analysis prior to ensure that you have like a stronger leg for your application to go forward through to registration. Now, you can file your domain name as your trademark if you are using it in a trademark manner. That is, if you are using your domain name to identify the source of goods and/or services. So think about Amazon.com. That is their actual domain name, which is your website name, your website address. But they also use Amazon.com for their online retail store services as a trademark to indicate the source of those particular services. That's a decision that you make, like Kat was saying, in your IP strategy as a business owner of whether or not you want to file a trademark application based upon how you're using that particular trademark.
All right, Christina, I'm going to stick with you. We've got a couple more trademark questions in here. Can you trademark a name and logo/design under one application?
Yes. So like we talked about, the definition of what a trademark is, any combination of what you are using, whether that's a logo, design elements, in wording together, you can file an application. But if you're saying, hey, I have two trademarks, I have a logo that I use alone, and I also have wording, terms, or phrases that I use alone, you would not be able to file them together and be able to get registration for both of those trademarks. So if you have two trademarks that you are using for whether it's goods, both for goods, then you would have to file two separate applications. But if you have a combination of those that you are using all together as one trademark, yes, you can file that application as one application. For an example, think about, again, I'm going to use Amazon. So Amazon has just Amazon. That is a registered trademark. And then they have Amazon with the smiley face or that arrow smiley face underneath. That is also registered as a trademark. And then they also have a trademark for just the smiley face arrow. That is a different application. So you see, if you're breaking those parts down or using them in different as different trademarks, you would have to file separate applications.
Continuing on with trademarks, is it advised to place the symbols TM, SM to establish ownership marks before formal registration, and how much time is available before registration is required?
Yes. So as soon as you're using whatever you're using, your brand, your brand name, your logo, if you're using it in commerce with goods and/or services, then you have a trademark. It's just not a federally registered trademark with the USPTO. So you are allowed to use the symbols TM for trademark, SM for service mark next to your trademark, and it's just putting someone on notice or the public on notice that this is a trademark. You wouldn't use the R with a circle around it until you file that application to get that federal registration or you receive your federal registration. There's no particular time that you need to file that application or file to get that registration. You make that determination as a business owner of when you want to go through that process. So you may say, I'm starting a business next year. I have these services that I'm going to be providing. I have a trademark that I'm going to be using, but it's not currently being used in commerce right now because you're not planning to use it for your business until next year. You can file an application if you choose to do so under what is called a 1B or intent to use. You will eventually have to show the office that you are using it in commerce in order to receive a registration for that trademark. Now, say you do already have a trademark that you're using in commerce, you want to go ahead and file, you may do so. Again, that's a decision you make as a business owner with your IP strategy about when you want to go ahead and move forward with that process.
All right, and then what about font styles for trademarks?
Yes, so anything that you are using as a trademark, whether that's different font sizes, different font stylization, color, the numbers, acronyms, letters, phrases, terms, words, design elements, whatever you're using could be a trademark if you're using it in connection with goods and/or services. So think about Coca-Cola has that typeface font, just Coca-Cola Times New Roman. They have that registered as a standard character format. That means that when they use it in the marketplace, they can utilize it any way or stylize it any way that they may so choose in connection with their products. But they also have that stylized script that we all know and is most recognizable as the Coca-Cola trademark. They also have that registered as a trademark as well, that very distinctive script.
All right, thank you, Christina. We're going to switch over to some copyright questions real quick. And I am just going in order, so I apologize if some of these are going to be repeat questions. We'll just answer them again really quickly if it's something phrased a little bit differently. But the next two questions are for copyright. So we have, does copyright apply to AI prompts? I'm going to pass on that question. I'm not going to speak for the Copyright Office. I know that they are working on, just like every other government agency right now, they're working on AI protocols. That is a decision for the Copyright Office to make, and I would suggest researching their website or reaching out to someone from the U.S. Copyright Office for more information on that specific question. The U.S. Copyright Office is through the Library of Congress. They are our sister agency. So we kind of just give this information, this general information on what copyrights is to kind of show the different types of intellectual property that you can potentially have as a business owner. But for more specific questions about copyrights, I would suggest reaching out to a representative from their office. And then the next question is, would a training presentation qualify for a copyright? As Christina mentioned during the presentation, anything that is written and is a work of authorship that is fixed in a tangible medium, so even if it's just a saved file on a computer, that can qualify for a copyright. So depending on what is in that training presentation, it could potentially qualify for a copyright. If you have a training video, that is something also that you can look into potentially registering a federal copyright for. I just, again, suggest going to their website, kind of digging through more of their resources that they have available for specific questions about specific types of material. All right, and then this next question we answered earlier, but just again to reiterate, overlap between trademarks and copyrights. There's overlap in all intellectual property. That's all a business strategy decision. It's an IP strategy decision for you to make. Again, we do not provide legal advice, so we cannot tell you what direction to go in with your intellectual property. We just highly suggest looking at the different resources available, making sure you're protecting it the way that you want to protect it. So in terms of trademark versus copyright, having that trademark be your brand name, that's a big deal. You think about it, you think about all those major companies that have their trademarks that are recognized internationally: Nike, Starbucks, Target, three of the really big ones. Those are all trademark protected. Copyright's just another way to protect the actual words or the actual work of authorship. So just look into how it would be protected and what you would be able to protect with that right before you before you actually file or register. All right, and then Christina, I think you had touched on this before, but just again, if you could reiterate, how can TM or SM, so those trademarks or service mark symbols, be applied to marks like domain names?
Yes, so again, if you have a trademark that you're using in commerce, our U.S. trademark rights are based upon usage. That's why I keep reiterating that it has to be used in commerce, not just something that you have in your mind that, hey, I'm going to do this with my business one day. You actually have to be using it in commerce. You can use TM for trademark or SM for service mark next to your trademark if you are using it in commerce with your goods and or services. This is just going to put the public on notice that this is a trademark. It doesn't indicate that this is going to be a registered trademark. We didn't talk about common law trademark usage rights. That is a whole other thing, but that is kind of putting the public on notice that this is a trademark that a person is using in connection to indicate the source of the goods and or services.
All right, thank you. And then we have another question on copyrights. Again, these are more specific questions with respect to copyright, so I do want to make sure that we're letting you know we are not the experts in copyright registration, so I highly suggest reaching out to the Copyright Office. The question specifically is about registering your logo for copyright in black and white when you might want to print it in different colors or in a different color combination. I recommend reaching out to a representative with the U.S. Copyright Office or looking on their website. They have great resources available just on their homepage that can help direct you to specific answers to your questions. And they might be able to provide somebody specifically to talk to you about that registration process and how to actually file your logo correctly to make sure that it receives the copyright protection that you're looking for.
And just quickly, just to jump in, I don't know if they did have copyright, but if they were referring to trademarks, then yes, you can file a trademark for in black and white or in color. It's just how you are using your particular mark. So if you were filing something in black and white, and say you have design elements and then it's black and white, you would be able to use, if you get that registration, you would be able to use that mark in any color that you want in the public when you're using it in commerce. If you file an application for a mark in color, you have to be using it in that particular, once you get that registration, you have to be using it in that specific color that that registration is for.
Thank you. All right, our next question, how do we find out who our examiner is? So this is specifically, I believe, for patents. What is the time frame for the examination process? My non-provisional has been in examination for over 3 months. Peter, I'm actually going to jump this one over to you since you definitely have the more experience with the time frames.
Sure. So once the application is sent into the patent office, so it goes under some processing to make sure that all the parts are there. And then we do a process where we classify it to figure out what is the subject matter that's the focus of this invention. So we will apply our classification symbol to the, or a combination of classification symbols to the application to figure out who is the examiner best suited to examine this application. So again, you heard Kat does exercise devices and Bert does kind of database oriented things. So, if you file for a widget, neither Kat or Bert examine that stuff. So it's not going to go to them. So let's say I'm the widget guy. So, hey, Peter is the one that examines widgets. So, we know that we need to send it to Peter and not to Kat or to Bert. So because every examiner is assigned to a specific subset of technology that they kind of specialize in. Which is a little bit different than in some other parts like trademarks. Everyone kind of can examine any assortment of other classes of trademarks. But in the patent side, every examiner specializes in a certain part of the technology. And so once we identify what technology to go to, we have a very complicated routing system where we know what examiner or subset of examiners that examine the subject matter. And so it's just a matter of when is there going to be space on that examiner's docket to assign this case to that examiner. So every examiner has a docket of cases that they're actively working on. So the docket will consist of new cases that they have not yet examined, and then cases that they've done initial examination and sent to the applicant, and the applicant has responded for them to take a second consideration or to respond to the applicant's amendments to resolve the issues that the examiner identified in the initial examination. So as there's more room on the examiner's docket, more applications will get routed to that examiner. So once we've identified what examiner or subset of examiners examine the technology, is just a waiting game to figure out when is somebody that's supposed to examine this case, when do they have room to examine my case? Until then, it's kind of on a central docket. So instead of like, hey, Peter's the only guy that can examine these widgets, it might turn out like Peter is one of 20 examiners that examine widgets. So as soon as there's space on one of those 20 examiners' dockets, it'll get assigned to them. When you file your patent application, whether you file through an attorney or you go it alone, you can request a status update, and then you can also check, because once you file the application, you will be assigned a patent application number. You can use that patent application number to look up the status in Patent Center. So with the that information, you could figure out, who is it assigned to. If it says central docket, that's the kind of the holding area that I was referring to, where it's waiting for someone that should examine the case to have space on their docket to examine it. Once you see a name assigned, that means that it's been assigned to an examiner. So that means that it's imminently closer to being actually examined, because we assign work to examiners. Once it's on the examiner's docket, that means that it's likely going to be examined within the next 4 to 6 weeks. And again, depending on the technology, some technologies have a very long backlog, right? So things that have to do with some of the newer technology like AI and blockchain and stuff, those are kind of very popular. So the backlog for that is significantly larger than in a smaller area like a fishing rod, right? You don't always know what the backlog looks like. So sometimes you'll just file and you're just content to wait. And others are, hey, I'm in a very important industry where I kind of need this to be expedited. That's where that expedited examination program that Kat talked about comes into play. So to put it another way, it's kind of a front of the line process. You pay the fee and you go to the front of the line. So it's kind of like the Disney World Fast Pass. So you get to kind of bypass the regular line and go to the front of the line, and you get examined in an expedited process. So again, once it's assigned to an examiner, it's a lot closer to being picked up and examined.
Thank you, Peter. And that kind of answers another question that we had in the chat. So why is the time frame for a patent, or what is the, I believe this question is asking more about what is the time frame for a patent to be completed from start to finish versus examination. So I do want to point out our pendency numbers that Peter was just mentioning. Those are available. The averages are available on our website. You can search patent pendency or trademark pendency to see the different average pendency timeline. But as Peter had mentioned, more complicated technologies that take longer, obviously can take a longer time to get through. More simple technologies might be a little less. So it just depends. But our current pendency for the first office action, so that would be the first time that you hear from your examiner on your application, is around 20 months right now. And then the total pendency, so from start to either grant or when you if you decide to abandon your application, which just means you're not pursuing that patent application any longer, is around 25.6 months. So that was where I was giving you kind of that 2 year and 2 month time frame for that pendency. So just to give you an idea, patents do take a lot longer to examine than trademarks. Currently on our website, the trademark pendency for that first action, so the first time you might hear from your examiner, is about 8.2 months. Again, that's the average. And then the total pendency that we have right now listed is 14.5 months. So just take those numbers into account. It may be less, it may be more. It depends on the technicalities and the formalities behind your application.
So real quick, Kat, one more thing to note. With the copyrights is just essentially a registration system. You file it and then it'll get registered into the Library of Congress. Patents and trademarks, those are examined and those have to be approved, right? So it could turn out that your initial patent application or trademark application can be denied, right? Because for patents, you have to come up with a unique and novel invention or a combination of features that makes it unique and novel. So if someone's already invented the same thing that you're filing a patent for, you're not going to get a duplicate patent because someone else already has the patent for that thing. So you might think I have a patent for a special widget, and it turns out that someone else has a patent for that widget. So it would be explained to you, you're not getting a patent because someone else has the patent for this widget, and you'd have the opportunity to amend and add additional narrowing amendments or to explain why the widget that the examiner thought was relevant is actually not relevant. So that process can take a while to go back and forth. And then also, once you get an office action from the examiner, there's a window in which you have to respond. So again, part of it is once the examiner works on it and it goes back to you as the applicant, you can respond immediately or you can take a few months to respond. And so part of that whole timeline and of how long does it take, you play a part in that too, because the sooner you respond, the sooner it gets back to the examiner. If you take longer time to respond to the examiner, then the examiner can't respond unless they have something to respond back to.
Thank you, Peter. Our next question, I've tried the pro bono program. I've gotten lost in the process, meaning no one returns your calls. So the patent pro bono program, those are independent or independently run depending on where they're located in the state. So within Texas, we have the Texas Accountants and Lawyers for the Arts. And then in the other states, they have different patent pro bono programs provided for you. Unfortunately, we have no control over how or when they respond, I would just suggest, again, reaching out to them as best as you can, and going through their independent websites to see if there's a different way that you can reach out to them. We do have all of the pro bono programs listed online. So if you just search USPTO patent pro bono program, it pops up with a map that lists all of the different pro bono programs that cover the different states. Some of the patent pro bono programs cover multiple states depending on where they are located. So just be aware that there might be multiple pro bono programs that you can reach out to if you're having difficulty with one of them. All right, and the next question, I believe, is going to be related to trademarks, Christina, but I'm not sure if this is one that we would be able to answer if it's more legalistic. So it says, I filed my tax ID number in 1996, and the other business popped up within the last 10 years or so. Can we both have the same name? Oklahoma Small Business said to just add OK at the end, so Oklahoma at the end, or to the beginning of my name.
So I wouldn't be able to like speak to like that specific situation, but the same as like we talked to like likelihood of confusion analysis. So think about if you have going through the process to file your application with the USPTO and received a registration, if that other company is coming through and they're filing an application with a similar name, the examining attorney in that I would presume that company would also be doing a search before they're filing that application to see if there are similar marks, confusingly similar marks for same related goods and or services. So if they have the same name and it's not the same identical related goods and or services, then they could go through. So think about Dove. For example, you have Dove for soap and Dove for chocolate. Those two registrations coexist on the register. They're identical marks, but they're for different goods and or services that consumers may not likely believe that a company that is providing something that is inedible is also providing something edible like chocolate or ice cream, the Dove brand for chocolate or ice cream. So that's the analysis that you would be thinking through to make that determination if you're saying, hey, I need to send them a cease and desist or something of that nature.
All right, thank you. And that also kind of touched on our next question, which was if your company name is similar to another, might it get denied? What are the rules on naming? Again, just as Christina has said, that's that likelihood of confusion. It's going to be an analysis of what your company is providing in commerce versus what another company is providing, and then going from there. So Dove, similar marks. Delta, we have that one as an example as well. You've got Delta Airlines, and then you've got the Delta faucets or the hardware. So just be aware that that likelihood of confusion is something to consider. But if you're in very, very different fields, you could still receive that registration. It's just something to look into and to think about when you're doing that registration process. Peter, I'll pass this question back over to you if you're able to answer it. For classified, how is the paper transmitted to the USPTO?
Right. So part of it is if as part of your research or your process of filing the patent, you received funding from a government agency or the military, you have to disclose that. Right. So that's one of the two paths that I talked about. And even if you don't, every application that comes gets through initial screening to figure out if the application is directed towards something that should be classified under secrecy orders. So in terms of how to fill out the paperwork, so most likely if you are trying to file a patent for something of this nature, most likely you're probably going to be retaining legal counsel rather than doing it on your own. So that attorney can probably walk you through that process. And then, so let me be clear. So the percentage of cases that get classified under these secrecy orders, very, 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 very low percentage. I think Kat showed us the slide earlier that said that, in fiscal year 23, we received like 600,000 patent applications. It's a very, very, very small fraction percentage of those. So it's not like it's a broad, wide encompassing thing. So yeah, so again, I think the question was earlier about like the ITAR stuff. So that's probably a good guess, right? So like, for example, like, hey, if my application is directed towards like munitions and firearms or some sort of like weapon system or, like military grade fuel or something like that, you know, it's probably going to be likely to like, hey, that's going to be subject to the secrecy orders. And so again, as you file that with the attorney will help you follow the necessary paperwork needed to file that and to make sure that it gets screened.
All right, thank you, Peter. Another question on trademarks and domain names for you, Christina. If the domain name is a website and a blog, but you will sell an online course of the same name, I think the question is just, would you have to have trademarks on multiple different things in that case?
So you can have, we don't go into like the different types of classes that you can have in an application. So when you file an application, you do have to identify what your goods and indoor services are. You can pull those identifications of goods and or services from our trademark identification manual. There are 1 through 45 classes. There are different headings or categories of different types of goods and or services. So you could have one application, that domain name that you're using for your blog, your website, etc., and for different classes. So you could have up to 45 classes in one application, should you choose to do so, or you may have 3, or you may have 2, et cetera, so on and so forth. So you would make that determination of, now are you currently using that mark in connection with those goods or those goods indoor services, and then you'd be indicating in your application what those goods indoor services are. So you could have one for the blog, based upon what the subject matter of that particular blog is, or those educational training videos that you have on that domain website, which would be in another class. So 2 different classes. That's just a determination you would make.
All right, thank you. And I think our last question that we'll be able to get to, what if your application, and this is for patent applications, what if your application is denied by one examiner and another examiner approves an application with some of the same claims under a different category? If my application is filed first, do I have any recourse? I can give a brief answer real quick that we are a first to file system. So if your application is filed first, you do have that prior date, that prior effective filing date that helps you out, but I will let Peter answer the recourse question.
So there's a handful of things. So I'm not exactly sure what the question meant in terms of a different category. So I don't know if they meant like a different category, statutory category, like a method versus an apparatus versus it's similar, but it's a method for doing this in this context or environment versus a different context or environment. So I'm going to try to guess what the question was directed towards, right? But again, so if your application was filed first, so let's say that I filed mine before Bert did, and it just happenstance that Bert got his application granted as a patent before mine did. There's a couple of things, right? So again, Bert's is only going to be effective based on the filing date of when he filed. So if he filed his in 2021, and I filed mine in 2019, mine predates it. Mine predates his. So nothing that I do is going to run afoul of Bert because I've been doing mine before Bert, right? Hopefully there's going to be some sort of distinction between what Bert and I do. Similar is not the same thing as identical. So it might be similar where like it's very similar, but there's a slight nuance that can happen because they could coexist. But if they're identical, then what's going to happen is, there's another process called a interference process, which we didn't get into, and I don't think we'll have time to get into now. But there's a process of kind of challenging, hey, my claims would be, there's an interference between the claims of my patent and the claims of Bert's patent. And so that's a separate process that goes down in terms of figuring out and resolving that, but that's kind of beyond the scope of the IP. That's not a basic question, so that's not part of this presentation, but there is a recourse if and when it does ever happen to you, hopefully won't, but that's definitely something that you could ask your attorney, patent attorney about.
All right, I think that is our last question. So Meredith, I will pass it back over to you. Oh, Meredith.
There we go. Yeah, we're good. Thank you so much. I just want to thank everyone on behalf of the Arkansas Small Business and Technology Development Center and our partner SPD offices in Texas, Mississippi, Oklahoma, and Alabama for joining us today. And I also want to thank Kathleen and Bert and Peter and Christina from the Texas Regional United States Patent and Trademark Office. We had some great questions, and I appreciate you taking the time to work through those. I hope everyone found today's session valuable and that it provided you with a clear understanding of the importance of IP protection for your business. You will receive an email with a link to the recording and a copy of the presentation slides. That should go out tomorrow or Thursday at the latest, so you will be able to revisit this content at your convenience. If you're interested in other events that we offer, you can check out our website or the website of your regional SBDC office. And that's it. Thank you again for joining us today, and I hope everyone has a great afternoon.
Thank you.
Thank you, everyone.